The first case that is on our agenda today is the state of Ohio versus Eddie Dukes. Attorney Angela Killey will be representing Mr. Dukes, and you will have up to 15 minutes for your argument. You may, you don't need to reserve because the state has waived its argument. The arguments are being live streamed and also are being recorded, so please keep your voice up. You should not use the names of children or minors or victims during your argument. The judges have read your briefs, Attorney Killey, and we are ready to proceed when you are.
Okay. Thank you, Your Honor. May it please the court. Attorney Angie Killey on behalf of the appellant Eddie Dukes. And the question that I wanted to raise with the court today to be presented is whether or not this verdict is against the manifest weight of the evidence. And although manifest weight is one of those things we are all obviously very familiar with and something that gets argued in almost every brief, it's not something that I normally bring up in an oral argument. But in this instance, I feel like this is the type of case that this standard of review was created for, where you all as judges are sitting as that 13th juror to review anything and everything that took place in this case, testimony and evidence, as it is a situation where it is that there's no physical evidence to support anything. And obviously I read the state's brief and I understand that they don't have to have physical evidence in order to support a conviction, and that that's often not available in a circumstance like this. But we are also talking about a very serious crime with a very serious punishment, and something that I feel the general public oftentimes, no matter how much they're voir dired, it makes people, it puts them on edge. So I think that there's a tendency to lean in the direction of an alleged victim when it's a child that's sitting in front of you. And I feel as though having, and I'm going to apologize, I don't know how to turn the ringer off the phone in my new office yet. Doesn't that figure? But they have, it's an emotional response that we get from people. And in this case in particular, I think what I would like this court to spend, I would ask the court to spend some time reviewing is the amount of potential suggestion with this child. Since we are talking about a child who is an extremely young age, but we have a situation where she didn't see a professional for almost a month after the alleged incident. And the testimony that was presented is that the very first person that she talked to is grandma. Grandma essentially says, I made her tell me. Then she says she had the child tell the appellant. So there's version number 2. Then the child was forced to tell her mother who has admittedly made an allegation of sex abuse against that child's father in the past that was proven to be untrue. Then she had to tell an officer who first came on scene. Then she was taken to the care center. Then she was, after the care center, she's been in counseling. It says she spoke to numerous teachers and numerous prosecutors. So even if I'm not counting individuals because I don't know how many teachers she may or may not have spoken to, we're talking to at least 8 people that this child spoke to and relayed information in regards to this alleged incident, and each and every one of them had the tendency to get a little bit different. Whether that's natural progression or whether that's any type of coaching is the thing that gives us cause for concern. Obviously, it's the appellant's position that he did not commit this offense and that this child may have been manipulated by the people who are involved in her life. And that is a question of absolute credibility, which is difficult for us at this level, but it is something that this court can review when sitting at that as that 13th juror. And
Counsel,
that's what yes.
Let me interrupt you because from my reading of the briefs, it seems to me, and from what your argument here this morning is, this young lady had to tell this what happened to her, allegedly happened to her, to multiple people, individuals, counselors, police officers, et cetera, et cetera. But the jury was aware that she had told the story over and over again, correct?
They were.
Okay.
They were aware. There was definitely some testimony as to how many times she had to tell the story. But I feel that coupled with the potential of that, and I know I argued it specifically with sufficiency, but the entire record is relevant as a review of manifest waste. I think the identification is also weak in this instance when that's coupled together. She very clearly said that the first 2 times she didn't see anybody, and then she said she just peeked her eyes open, which raises a red flag to me that there's a lack of identification, as well as the fact that she had to repeat this story in so many different circumstances.
Well, what I was getting at,
Yes.
and it's unfortunate, it's, as a matter of fact, it's horrendous that a victim, any victim would have to keep repeating the alleged incident over and over again. But I guess what I'm wondering is, why would it not be reasonable, knowing that the jury, knowing that this child had repeated this story over and over again to individuals, and maybe there were some differences, but she never recanted from the fact that step grandpa had digitally penetrated her.
Okay. So you're asking me why would it be unreasonable for the jury to make the finding that they found her credible?
Well, because you're saying we're supposed to set as the 13th juror, so how is that unreasonable for them to make that determination? Because we'd have to say it was unreasonable.
You do have to say it's unreasonable, and well, that's a tough one, Judge.
And I don't mean to laugh either.
No, because I
Just
can't.
how you responded.
Obviously, I can't look into you all's minds, but I suppose my hope is that the unreasonableness can come from the fact that you all, as judges and a little bit more neutral arbitrators, may be able to look at this with an eye that's not just as sympathetic. I feel like a jury has a tendency to look at a child alleged victim and immediately give them credibility. And I think that Mr. Dukes deserves, and any criminal defendant deserves, people who are neutrally going to look at all of the facts objectively and leave the emotion out of it and verify. And it's our position that it is insufficient. It was not enough evidence in order to support it. I really feel like this is a situation where there is so much potential for influence on this child during the course of what she was telling people that it takes away from her credibility in a fashion that doesn't make it rise to the level of what it needed to be, which was proof beyond a reasonable doubt. Don't know if
Attorney Kelly, a couple of questions that I have. Did the evidence show that there were 5 people in the house when this happened?
There were 3 children. Yes, 3 children and 2 adults. And the evidence was so I believe at the time that it was supposed to have taken place that it was just my client and his wife, ex-wife, not really sure. She kind of acted like she wasn't his wife, but he said that she was his wife, that were in the home. But there was also testimony that mom had been back and forth a lot during that week. So I'm not 100% sure what days and times she was there.
And was there some testimony in this case about somebody seeing Mr. Dukes near the room where this alleged? Okay.
Yes, there was. His wife gave some testimony that she had seen him come out of the children's room at night. And he actually told the police that he was in the children's room at night, that he had gone in there to cover up the baby. That was what he told them on the day of the incident when it was reported. And that's also what he told them when he testified during trial, that he was in there. So there's no question he was in the room.
Can you share what you think changed in the child's version that would make it unreasonable for us to, or a jury to come to the conclusion that it did?
Well, there was certainly a progression, and I can't, as going through each individually, I know the state kind of laid them all out, but there was a digital penetration on all, but there were times that it included anal, there were times that it was just vaginal. And she seemed to kind of flip-flop back and forth as to how much actually took place. And the one thing that I feel didn't get, the one other thing that came up that to me that was discredited was the issue about whether or not she needed to go to the bathroom constantly. That was something that grandma and mom made a big deal about, that they noticed that she was going to the bathroom and this and that. And she went to the doctor. Doctor said that that's usually caused by an infection, and she had no infection. That's something else that gave me some cause for concern, but it was really just a matter of her switching. And I felt like as she progressed through in her testimony, at least, that she made a lot of adult style statements that almost would seem that they'd come from somebody else. I know in particular, and I can't remember what page it was, but the one that stuck in my head when I was reading everything was that she said that when she told my client what he had done to her, that, quote, he tried to pretend like he didn't know what I was talking about. And that just to me sounded like something that would come from an angry wife, not from a 10-year-old child. Like, he's not being truthful with me. So, and your honors obviously are capable of looking through all the evidence to verify how much you feel changed or didn't change and have a difference of opinion than me. But this is really what I feel is the focus of this case, or the crux of this case, is the manifest weight issue. Obviously, I raised some other arguments, but it was not my intention to discuss those today unless any of your honors have a specific question about them. No? Okay. If that's the case, then I'm willing to rest on my brief for the rest of it. I'm very brief today. Sorry.
Well, thank you very much for your presentation. The court will take the matter under advisement and issue a decision in due course. The clerk of courts will mail a copy of the decision to you on the day it is released, and the opinions will also, of course, be posted on the Ohio Supreme Court website. Thank you very much.